So it has been fairly widely reported that Kamala Harris is more than likely going to be named Joe Biden's VP, his vice presidential running mate, and it's kind of, I think, important to realize the type of politician that she has been since being, a U.S. senator from California, as well as when she was the so-called top cop in California when she was the attorney general there. This is an article from the American Prospect. I'll link in the description box down below. And the audio quality of my videos should be much better now. I just picked up a microphone that you can see a little bit right there. So, title this article: How Kamala Harris Fought to Keep Nonviolent Prisoners Locked Up. Fix that. As California Attorney General, she spent years subverting a 2011 Supreme Court ruling requiring the state to reduce its prison population. The overseeing judicial panel nearly found the state in contempt of court. I mean, just that title alone, for God's sakes. I mean, obviously, the United States is not the land of the free when we incarcerate more people than any country on earth, largely for nonviolent drug offenses. And as California's Attorney General, she didn't want to let those people out of jail, even though the Supreme Court was requiring it at the time. I mean, for F's sake. Senator Harris, a leading candidate to be Joe Biden's running mate, repeatedly and openly defied U.S. Supreme Court orders to reduce overcrowding in California prisons while serving as the state's attorney general, according to legal documents reviewed by the Prospect. Working in tandem with Governor Jerry Brown, Harris and her legal team filed motions that were condemned by judges and legal experts as obstructionist, bad faith, and nonsensical. At one point, even suggesting that the Supreme Court lacked the jurisdiction to order a reduction in California's prison population. And, I mean, obviously say what you want about the Supreme Court, but they are the highest court in the land, whether you like what they rule on or not. That kind of obviously translates down back to the lower courts and the state. So Harris and her office saying they lacked jurisdiction, that is quite nonsensical, as this article points out. The intransigence of this legal work resulted in the presiding judges in the case giving serious consideration to holding the state in contempt of court. Observers worried that the behaviors of Harris's office had undermined the very ability of federal judges to enforce their legal orders at the state level, pushing the federal court system to the brink of a constitutional crisis. This extreme resistance to a Supreme Court ruling was done to prevent the release of fewer than 5,000 nonviolent offenders, whom multiple courts had cleared as presenting next to no risk of recidivism or threat to public safety. Again, people getting locked up for nonviolent offenses, that obviously shouldn't happen in the first place. And what only threat they would pose to public safety would be, just the messed up nature of the carceral state. You get locked up, you have that, felony label on your record. It's going to be a lot harder to find, a good job that pays a livable wage. But I mean, it's just ridiculous. And Joe Biden's running mate, and obviously Joe Biden has his own sordid history when it comes to things like the crime bill. And obviously, a whole lot of other things, wanting to cut Medicare, Social Security, supporting the Iraq War, bragging about working with segregationists, wanting to veto Medicare for all if somehow it passed, etc. Despite a straightforward directive from the Supreme Court to identify prisoners for release over a 2-year period, upholding a 2009 ruling that mandated the same action over the same timeline, the state spent the majority of that period seesawing back and forth between dubious legal filings and flagrant disregard. By early 2013, it became clear that the state had no intention to comply, leading to a series of surprisingly combative exchanges. And I mean, again, Joe Biden has said if he gets elected president, nothing would fundamentally change. While Harris's ultimately unsuccessful presidential campaign saw questions raised about her criminalization of truancy, again, she was basically locking up parents for their kids being truant. How is that going to help those kids not be truant if their parents are getting locked up? I mean, just that alone should be disqualifying, for God's sakes. And her not wanting to legalize marijuana either. Her tough on crime reputation during her time as San Francisco's district attorney. Her role in California's prison reduction case largely flew under the radar, though it was decried at the time. As concerns grow about Donald Trump's subversion of the law, he, along with Attorney General William Barr, fascists, both of them, is currently defying a Supreme Court ruling by refusing to restart the Deferred Action for Childhood Arrival Program, DACA. The potential Democratic vice presidential nominee engaged in relatively similar obstinacy is jarring. Senator Harris' office has yet to respond to a set of questions from the prospect. How did Harris' office turn a simple court order to release low-risk prisoners to prevent cruel and unusual punishment into a constitutional fiasco? Federal courts seldom look to prisoner release. It's a remedy of last resort, but California was a unique case with its uniquely awful prison system. At its height, it was stuffed to some 200% of its design capacity. Again, end the war on drugs, end the prison industrial complex, defund the police, work towards abolishing them, work towards abolishing the carceral state. hugely racist as well. There are not enough beds or medical personnel, but an extreme excess of bodies. In one prison, 54 prisoners shared a single toilet. Preventable deaths due to substandard and overstretched medical care occurred every 5 to 6 days. Suicidal inmates were locked in telephone booth-sized cages for more than 24 hours at a time. I mean, and really, like, that's going to help people be less suicidal? Like, for fuck's sake. For nearly 2 decades, Republican and Democratic administrations essentially ignored the problem despite constitutional protections for prisoners against cruel and unusual punishment enshrined in the Bill of Rights. I mean, for God's sakes, all of this is cruel and unusual. Finally, in 2009, an earlier there's a moth in here. A federal district court found that no other plausible solution existed for getting the state to conform to a constitutionally reasonable standard than a forced prison release. I mean, again, what else can you do? It's packed to the gills, 200% capacity, 54 prisoners, 54 incarcerated people sharing one freaking toilet. The district court mandated the state enact a series of decarceration measures to reduce the population to, I mean, look at that. And it's like what they're requiring isn't even obviously all of that, progressive or outrageous, to only reduce it to 137% of its design capacity. Like, really? Shouldn't it at most be at 100%, for God's sakes? State appealed. Supreme Court was in violation of prisoners' 8th Amendment. So that's what the Supreme Court ruled in 2011. The verdict split, with conservative Justice Anthony Kennedy joining the court's liberals. Kennedy wrote the majority opinion in the case, including an array of gruesome details from inside those prisons and condemning the state for facilitating needless suffering and death, as he called it. At that point, Harris had been AG for over 4 months. But the ruling would have to be enacted on her watch. Every 6 months, the state would have to show it had decreased its population in compliance with the threshold overseen by a 3-judge district court panel. 167% capacity by the end of 2011, 155% by June 2012, finally arriving at the target level of 137% and 0.5% by June 2013. Soon be clear that the state would hold out on complying with the judicial order. 2011 passed with little progress made on the decarceration mandate. Jesus. And then look at this. A report surfaced that proved the state actually intended to increase its prison population. In May of that year, Harris' office confirmed their intent not to comply with the order, but instead to seek its modification from 137.5% design capacity to 145. Modification was not permitted. The deadline for compliance was eventually extended to the end of June 2013. Harris has been, yeah, I mean, for God's sakes. This is still at almost 10,000 more than the ruling allowed. I mean, Jesus Christ, dude. And then they're saying that the Supreme Court had no jurisdiction to even request such a release, refusing to answer questions as to how they would implement the Supreme Court ruling and a constitutional crisis. That resulted in a stunningly sharp rebuke from the three-judge district court panel in June 2013 ruling. When asked by what date the state could identify their list of prisoners who are unlikely to offend, defendants defiantly refused, the judge wrote, and stated somewhat astonishingly that our suggestion that we might order defendants to develop a system to identify low-risk prisoners, a system that the Supreme Court had suggested we might consider ordering defendants to develop without delay. Damn. Yeah, and the Supreme Court ruled that that three-judge panel had that right. I mean, Jesus Christ, dude. There's Brown, Harris, both big proponents of the carceral state, it seems. Harris was acting on behalf of the state's governor, who preceded her as AG, who is notorious for his posture on the issue as well. But she might have chosen not to defy. Her work in particular not only drew ire from the court, it also raised eyebrows among observers. Defiance of the federal court order requiring the reduction of the California prisoner population is reminiscent of Southern governors from the 1950s declaring their defiance of federal court desegregation orders. Erwin Chemerinsky, dean of UC Berkeley Law School, told NPR at the time, both were misguided efforts to undermine enforcement of the Constitution. Added Barry Crisberg, longtime president of the National Council on Crime and Delinquency, the legal arguments that the state is putting forward make no sense. I mean, for God's sakes, I'm not going to read all of this, but it's just disgusting. And then check this out. Of course, Harris has been criticized on multiple occasions for fighting to keep people, there's that moth in the back, including innocent ones in prison. In the case of Daniel Larson, an ex-felon sentenced to 27 years to life under California three strikes laws. Harris argued that even if Danny was innocent, his conviction should not be reversed because he waited too long to file his petition. So she's basically okay with somebody who's completely innocent of the crime rotting in prison for the rest of their lives. This is Kamala Harris. It's disgusting. Let's see. And then we have the stuff with the truancy. We have this defying the Supreme Court ruling to reduce California's bloated prison system. I mean, it's again, this was from Alexander Salmon, staff writer at the American Prospect. This is right up Joe Biden's alley, though. Again, nothing will fundamentally change under a Joe Biden administration. He has said that many times, and his policy platform is just another example of that. And Kamala Harris likely being his VP with her horrible record, especially as a attorney general, and the the district attorney, I think, for San Francisco, reflects that idea as well. Peace. Much love.